Excited to be here, and I'm very excited to introduce to you the Honorable Martha Lee Walters. She is a justice on the Oregon State Supreme Court here. She's been serving as a justice since 2006, and before that she actually was a lawyer for about 30 years. She ran her own law firm in Eugene, and she did civil litigation, like the case we're doing today, except she focused mostly on employment law. So she is the perfect person to give an example of a closing argument, and she is also one of the coaches for our team. So without further ado.
Well, thanks, Caitlin, and thank you all. I'm sorry I haven't been here as much as I would have liked to be. It was really great coaching last time, and I can tell you that you guys have the commitment and the ability that actually exceeds in many ways that of the coaches. Our students last time when we were finished with coaching and our competition said to us, you know, you guys could be a little bit more organized. You could work a little harder next year. So we can learn from you and we can challenge each other. And so what I'm going to do today when I talk about closing statements is challenge you a little bit, because I know you've already been here for 2 days and you've already learned a lot of what I'm going to tell you. So I want you to chime in, because I think from what you learned from Judge Hernandez when he started was a lot of the same things that I'm going to tell you about the closing. So the purpose of closing argument is the same as the purpose of all parts of the trial, and that is to persuade the jury to agree with your side of the case. When you represent the injured person who is the plaintiff, then you are the one bringing the claim and trying to show that the other side, the defendant, was at fault. Now, when you're representing the plaintiff, you always want to call her by her name. She is a real person who has been injured. From the same token, when you represent the defendant, that's a corporation. When you're the plaintiff, you call the defendant the corporation, the defendant. They are an entity that has no people associated with it. But when you're the defendant, you explain, these are real people. We're part of a company, but we're real people too. And we're being wronged in some way too by being wrongly accused. Then you have to, how do you go about convincing the jury that your side is right? First, number one, you must yourself believe. You have to believe that your side is right. You cannot sell anything to someone that you would not buy, right? You've got to believe it or it's not going to come across. Second, number two, you have to be believable. You have to look the jurors in the eye. You have to speak with conviction, and you have to be accurate. You can't state facts how you want them to be. You can't state facts. This is very important in mock trial. This is in real life, but in mock trial it's really, really hard, because there's things in these written statements that people make, and you get them in your mind and you're preparing your closing argument and you think all the evidence is going to be what's in those written statements. But sometimes the witnesses don't actually say those things. It happens in real life too. You think the evidence is going to come in a certain way and it doesn't. So you've got to be very attentive during the whole trial and listen. And don't talk about things in the closing that weren't actually said, because you're not going to have credibility if you do that. The jurors will remember whether what you say is the evidence really was the evidence. And don't state it to be better than it was, because then what are they going to trust you? The whole purpose of your being there is to have the jurors trust you, so that when you ask them to do what you want, they will trust you and say, yes, that makes sense to me. I trust that person to be accurately telling me the facts and the law. and I will believe that person. If you come across in your closing argument as competent, as knowing all the facts, as correctly relaying them, then the jury is going to be more likely to also agree with the result that you ask for. And you must be candid. You must admit the facts that aren't good for you and then give an explanation for them. Because otherwise the other side is going to bring up those facts and you never want to bring them up. I can't tell you how much this happens in real life. You always want to pretend that those bad facts aren't there and that you don't need to explain them. You don't want to bring them up, just kind of hoping that the jury will forget them. But you can bet that the other side will bring them up, so you have to have your explanation for those facts ready. Then third, you've got to give the jury reason to believe you. So you want to have conviction, you want to have emotion, but that's not enough. You have to have the facts, and then you have to connect those facts to the law, because they're not going to know just what to do with facts. They're going to be given instructions. I don't know if we haven't talked too much about jury instructions, but the judge will, at the end of the case, tell the jury what the law is. That the law is you can hold the defendant responsible in this case if you find that the defendant was negligent or unreasonable or failed to exercise ordinary care. And here's how you determine whether that did or did not happen. So as the lawyer in the closing, you need to say, here's the facts, and here's how we know they match up with the law. Then you need to ask the jurors for the result that you want, and you need to give them the moral and legal reasons for them to reach that result. The jury wants to do the right thing, and they will try to follow the law, but they want to believe that they're right beyond just the law. They want to believe that they're reaching the right result for the right reasons. So they need answers to the questions that they might have. Now, they're not going to be able to raise their hands and ask you those questions. So you're going to have to anticipate what's the other side going to say and what's your answer to that. You know that one of our United States Supreme Court justices now is Sonia Sotomayor, and she wrote a biography that's really a great book. I haven't read it yet, but I keep hearing it is, and I keep wanting to put it on my list. And she said that one of the things that was so important to her in her life was being part of the debate team, which is similar to what we're doing here. And the reason it was so important to her is because she saw both sides of the question. She didn't just look at things from her own perspective. She learned through debate how to look at how other people look at it and what the answers were, and she could see both sides. So that's what you need to do in your closing. You need to think, what's my side, but what's the other side, and what's my answer to that? Number four, you have to speak so that the jurors will listen. If you're in a monotone reading, looking down, they're just not going to listen to you no matter how brilliant it is, what you have to say. So I think that Judge Hernandez told you at the beginning all the different ways of slowing down or modulating your voice or changing the pace and speaking real fast and then pausing. Tell a story. But most of all, don't watch me. I mean, you can watch me, but don't try to imitate me or Justice Peterson or anybody else who's given presentations for you. You have to be yourself. It's not going to feel right unless it's who you are. It has to be authentic, and it takes a lot of courage to do that. But one thing that you can do that I've found really helpful for myself is I try not to think about myself. I try not to think, oh, I wonder what they're thinking about me. I wonder if they're thinking I'm doing this right. I try to think about my client, the real person that you're representing. That person can't speak to the jury, and so you're speaking for that person. So you try to think, what am I trying to communicate for that person? Think about what you're saying, what you're trying to get across, and take yourself out of the equation. This person who was injured who was wrongly accused, and what it means to him or to her or to others who may be wrongly injured or wrongly accused. And if you tell the jury how your client was wrong and how they can help, and if you use your head and speak from the heart, then you will give the only closing argument that anyone can ever expect of you. And I can't wait to see how you do it. And now I'm going to have to try to demonstrate all that. And if you don't see me doing it, you'll see Justice Peterson. He's had more experience than I have, and maybe you'll see a good example there. So how should we do it?
Well, I was just thinking, this is our jury, isn't it?
Yeah.
Who's going to be our judge?
Vanessa. I'll be the judge.
Okay, well, why don't we just
Start here.
make our arguments from the same place that you were?
Okay. All right. Is that okay? All right. This is a giant jury box. It makes it a little harder. Let's see. Gotta find what I'm gonna say for this. Your Honor, I'd like to reserve 2 minutes for rebuttal. Ladies and gentlemen of the jury, thank you for sitting here so patiently over the last 2 days and for listening so intently. You'll remember, if you think back to the beginning of this trial 2 days ago, that the lawyer for the defendant, Cup of Joe Corporation, told you that this case was about responsibility. Remember that? And he was right. This case will soon be in your hands, and it will be for you, the jury, to decide whether Defendant Corporation should be held responsible for the severe and permanent damage suffered by Dolores Cervantes when Defendant Corporation served her a cup of coffee that was dangerously hot in a dangerously flimsy cup. The decisions that the Defendant Corporation made to do that were not accidental. Those were deliberate decisions that they made after thinking about what they were going to do. The sudden jolt that happened when the car went over the bump, that was an accident. But the decisions that the corporation made to brew their coffee and keep it and permit their employees to serve it at up to 190 degrees, and to do so in a flimsy cup where the top could pop off on such a jolt, those were deliberate decisions. And they demonstrate that Defendant Corporation did not use reasonable care in making those decisions. They did not use ordinary care. Mr. Flores testified, and you will remember that that the Defendant Corporation knew that over 100 people had suffered serious injuries from its coffee. Yet, he said, we didn't think we should consult a burn expert. The defendant's witnesses testified that any liquid over 140 degrees created a hazard of burning. Yet they brewed their coffee and permitted it to be kept at up to 190 degrees. How hot is that? It's off the charts. You saw the chart. It was Exhibit 2. As high as that chart went up was to 160 degrees. And at 160 degrees, you could suffer third-degree burns at 1 second. That's at 160. This company maintained their coffee at 190, 30 degrees higher than that. What were they thinking? Well, we know what they were thinking because their witness testified the profit margin in coffee is important. Profit. Then they tried to shift the responsibility. They said, well, we've done a survey and people want their coffee hot and people want their coffee cheap. Well, 140 degrees is pretty hot. Did you hear any testimony that people wanted their coffee at 190 or 156 where it could cause immediate damage to the nerves? No. What they said was, we brewed the coffee and kept it at 190 so it would stay hot. They wanted it to stay hot. But all they had to do to keep the coffee hot was to put it in a foam cup that their own employee recommended, the foam cup. But wait, maybe they couldn't put it in a foam cup because that would cost too much more. How much? 3 cents a cup? Would they lose that in profits? What if they just had a cup that didn't have 2 colored logos on it? What if they had a cup that you can buy with no logos on it? Costs less. Foam cup costs less than one with 2 colored logos. Plus, that foam cup, it had added stability, added crush resistance, and a double lock top. It was safer. Was it reasonable not to use the foam cup? They did a survey. They said this is what people want. People want hot, they want quick. Did they ask the people, do you want it so hot that it can cause 3rd-degree burns that will melt your clothing to your skin in less than a second? Did they ask the people, do you want a cup that has 2 colored logos instead of a stable cup? This defendant corporation tried to shift responsibility in this instance to the public. And then they tried to shift responsibility, you heard them, to Dolores Cervantes, holding a cup of coffee in a car. She comes to a drive-through, she buys a cup of coffee at a drive-through, and she's holding it in her hands. Does that demonstrate that Dolores Cervantes was at fault? Then they said, well, everyone else does it. Other people in the industry do it. Well, I remember that my husband's mom told him, just because Hugh Powell does it doesn't mean you can do it. And he told that to our kids. And he was right. And the law is the same. The law specifically says the custom in the industry cannot overcome the requirements of reasonable safety and ordinary care. Each corporation must be responsible for its own actions and for the harm that it causes. Dolores Cervantes is asking that you compensate her for the harm that she suffered, for the burned skin, for the pain medication, for the repeated surgeries, and for what really are ugly and disfiguring scars. She told you about the pain that she felt, and she had to show you what it looked like. When we go home tonight, we're all going to find things that we like, that help us to get through the difficult days, things that make life great for us, things that make the hard times worthwhile. For Dolores Cervantes, that was tennis and that was guitar, making music. You can't give that back to her, but you can hold the defendant corporation responsible for that loss. We ask that you return a verdict for Dolores Cervantes and against the defendant corporation. Thank you.
minute and introduce Chief Justice Peterson, although I know everybody knows him, but you haven't had an official introduction. And he's been a leader and a friend and a mentor to many of us, and we're so happy to have him here. And I just want to thank him for everything he did. Along with Chief Justice Demunis, he was one of the initiators and leaders of the mock trial. It was his idea, and he's been a real friend, I know, to different communities. He was a leader of the 1994 task force looking at racial, ethnic issues, and the judiciary, which served as a platform for a lot of improvements. So I just really like to highlight all his achievements. He's received an award from the U.S. Supreme Court, the Lewis F. Powell Award. There's an award, a very prestigious award given by the Oregon State Bar in his name, in his honor every year. So he really is a leader, and we all just want to thank him so much for everything he's done for all of us.
Now let's try to get back in the trial mode. You've just heard an eloquent closing argument by Ms. Walters, and I'm the attorney for Joe's, making the closing argument for Cup of Joe's. So, may it please the court, Ms. Walters. There's really one pivotal issue in this case, and that is, was that lid properly put on a cup of coffee? Now the plaintiff has filed a complaint against the defendant, claiming that the defendant was negligent in certain ways, including failing to properly secure the lid on this cup of coffee. So you'll notice that Ms. Walters, the counsel for the plaintiff, said almost nothing about this issue. When you retire to deliberate, she wants you to just focus on the temperature of the coffee. But I submit, ladies and gentlemen of the jury, that the pivotal issue in this case is, was that lid properly affixed to that cup? And I submit to you that if your answer to that is yes, then your verdict should be for Cup of Joe's. Now, the plaintiff has brought this lawsuit, and she's made that allegation against us. And the judge is going to instruct you at the end of the case that the plaintiff has the burden of proving fault on the defendant. And I'm going to try to convince you that the plaintiff has failed to satisfy that burden. So one of the things you're going to have to decide when you retire to the jury room is what actually happened that day. There's quite a conflict in the evidence concerning the events of the day that the plaintiff was injured. So first of all, I'd like you to focus on this question when you go into the jury room. Why did that lid come off? What is the most likely explanation for that lid coming off? What does the evidence show? Well, first of all, we start with the person who made the coffee and who affixed the lid in the first place, Mr. Fry. He testified that the lid was secure. What did Mr. Fry do? He handed the cup to Ms. Garcia. What did Ms. Garcia testify to? The lid was on the coffee. Then what happened to the cup? The cup went from Ms. Garcia to Ms. Cervantes. Was the lid on the coffee? Unquestionably, the lid was on the coffee. The plaintiff did not testify to the contrary. What else did the defendant do? The defendant, on the side of the cup of coffee, was a warning that was affixed to that cup, a warning that the coffee was hot. Now let's talk about Ms. Garcia. You'll remember the cross-examination of Ms. Garcia this morning when she testified to the to certain facts regarding the occurrence. Number one, Ms. Garcia remembers that Mr. Fry made the warning. It was not only on the cup, but he said, this is hot. And Mr. Fry has been unswerving in his belief and in his testimony that the lid was properly affixed to that cup. I'd like to quote from the testimony of Ms. Garcia. And I'm referring counsel to page 27, lines 29 through 31. Ms. Garcia, I remember the cashier saying something about the coffee being hot. Then continuing, I don't know if Dolores heard what was said or not. Of course, coffee is hot. Then we lurched forward because of a drop from the curb area to the street. And then we have this crucial sentence. That's when Dolores spilled the coffee. You'll notice she didn't say, that's when the lid came off. She said, that's when Dolores filled the coffee. I don't really question the credibility of Ms. Garcia in any way. That was her testimony, and that's the testimony I think you should consider when you go into the jury room. Now let's look at the testimony of Ms. Cervantes itself. We all regret that this occurred. We don't deny that Ms. Cervantes has been injured. But the law requires that they prove that we were at fault. And there's also some laws concerning the requirements of due care by Ms. Cervantes herself, and I'll get to that in a minute. What did Ms. Cervantes say? The lid was on when she got the coffee. Ms. Cervantes said that in her cross-examination this morning, she said, Ms. Garcia, you can believe what Ms. Garcia says. Ms. Cervantes, excuse me, was in this SUV. Her testimony was that she intended to open the coffee when she got to work. If she intended to open the coffee when she got to work, why did she ask for cream and sugar? You'll recall her testimony that there was cream and sugar available at work. Now there's a lot of, the court may instruct you about inferences that you can make, but I suggest that the inference that you should make and that you should find is that Dolores Cervantes was, when she bought that coffee, intended to open the lid and drink it while she was still in the car. Another fact, the testimony was that this was an SUV. There was a cup holder available for Ms. Cervantes to use. If she was going to just keep the coffee in the cup and not consume it before she got to work, what would you have done with that cup of coffee? Would you have kept it in your hand as Ms. Garcia drove off? Or would you have put it in the cup holder? You know the answer to that question. Did the plaintiff squeeze the cup? This car, according to the testimony of both the plaintiff and Ms. Garcia, the car lurched and it either hit a bump or it more likely went over the curb. And that's when the coffee came out of the cup. More likely than not, the cause of that was the plaintiff squeezing the cup because she was holding it in her hand. Now, in rebuttal, the plaintiff may say, well, it's still Joe's fault because they should have had a more secure cup. I suggest there's an awful lot of speculation in that statement. Almost every issue in this case involves conduct in which the plaintiff, Ms. Cervantes, was in control. She was in control of the cup. She was in control of where she put the cup. The evidence shows that Cup of Joe has sold many, many cups of coffee, probably thousands out of this very coffee shop, without the result that happened to Ms. Cervantes. Now, the judge is also going to tell you that you should consider the fault of the plaintiff. Now, granted, the defendant has the burden of proving fault on the plaintiff. And then I'm going to get, in a minute or two, I'm going to tie these two issues together. Just very briefly, the evidence regarding the plaintiff's fault includes this. Number one, the failure to use a cup holder. And I ask you again, what would you have done if you intended to consume that coffee on the way to work? I mean, when you got to work. Two, why did the plaintiff get cream and sugar if there was cream and sugar at work and she intended to consume the coffee when she was at work? Three, there was a lurch. There was a bump. The Cup of Joe had nothing to do with that. Four, we have the warning that's on the cup itself. I have here a blow-up of Exhibit 3, the cup of coffee. And what does that blow-up say right on the side of the cup? Caution, contents may be hot. And finally, I suggest that you must conclude that the plaintiff squeezed the cup. So the plaintiff's fault, even if you find the defendant at fault, when you weigh the fault of the plaintiff and the defendant, I suggest that your conclusion should be that the plaintiff's fault is much greater than that of the defendant. Now I'd like to invite your attention to the verdict form, which is on page 13. You are going to be asked 5 questions. And the first question is, was the defendant negligent? I submit to you that your answer to that question should be no. And if you answer that question no, that ends the case. And you don't go on to any of the other questions. Then, but if you find that the defendant was to some extent at fault in this unfortunate occurrence, then you're going to have to go to question number 3. Was the plaintiff negligent? And I suggest that the evidence is overwhelming that the plaintiff was negligent. And then question number 4 is going to be, was the negligence of plaintiff a cause of plaintiff's injury and damage? And then I suggest your answer to that should be yes. And then question number 5, if you get to this point, you have to apportion the fault between the plaintiff and the defendant so that the fault totals 100%. And as I have suggested earlier, your conclusion should be 1, no fault on the part of the defendant, but even if you do find fault on the part of the defendant, the overwhelming burden, the overwhelming weight of evidence is in favor of a conclusion that because the plaintiff was largely in control of this situation, the major degree of fault reposes with Ms. Cervantes. And I repeat, we regret this unfortunate accident. But that's all it was, ladies and gentlemen. It was an unfortunate accident. So in closing, I'll just ask you 3 questions to consider when you go into the jury room. I have no doubt that you're going to consider this case objectively, fairly, and dispassionately. The first question is, what is the most likely explanation for the event? Well, the most likely explanation for the event is that the plaintiff took the lid off the cup. But even if you find that the lid came off when the cup was squeezed by the plaintiff, that's active conduct on the plaintiff's part. So I thank you. You've been an attentive jury, and after you hear the court's instructions, I respectfully suggest that your verdict should be for a cup of Joes. Thank you.
The question posed was the lid on the cup? Notice the question posed was not, did Dolores Cervantes take the lid off the cup? And that's because no one testified that she did. Ms. Garcia did not see her take the lid off the cup. Yes, the lid may have come off the cup because the cup was flimsy. But if she took the lid off, it would have been seen and there would have been testimony to it. She's not at fault for holding a cup. She's not at fault for, when going over a bump, squeezing the cup if she did. The cup should be able to withstand normal use. What if a car company made a car with terrible steering because it costs too much to make good steering? And let's say that a squirrel comes running across the road and the driver grabs the steering wheel and tries to turn. Are we to say that the company that manufactured that car without decent steering is not responsible when it made a deliberate decision to not put good steering in the car because a squirrel might run across the road and that absolves them from all responsibility? Ladies and gentlemen, before Dolores Cervantes was so severely injured in this case, before her hands were permanently scarred so that she couldn't play the guitar anymore, over 100 people had been seriously injured by this hot coffee in these flimsy cups. Now there's 101. How many more will it take? That's it. All right, should we go practice?